the Nevada State Board on Indigent Defense to order. So if we can start off with a roll call vote, that would be wonderful.
Okay, I'm all set.
Thanks,
Kate
Stacy.
Thomas,
I'm here.
Joni Eastley, Chris June Kellyani.
Here.
Sorry, I think I was muted. This is Joni. I'm on the phone.
Perfect, thank you. Eric Blakey.
Here.
Susan Bush.
Present.
Angela Cook. And Lorena Dellinger, I talked to her. She's just going to be a couple minutes late, but she will be here. Joe Krim.
I am here.
Allison Jaffe.
I'm here.
Abigail Frierson, I spoke with her and she won't be able to attend. She has another meeting. Jared Hickman.
Here.
Ben Gommond.
Here.
Justice William Maupin. And then Judge Gary Fairman.
Here. Here.
Right. All right, thank you. It sounds like we have a quorum. All right, well, we'll jump right into public comment, and this is our first public comment period, and we're asking that people please limit comments to items on the agenda, and we're not going to take any action on what is being discussed here. And if you could please limit your time to 3 minutes, I would really appreciate that. Do we have anybody that is looking to make any public comment? Either please raise your hand or chime in if you feel so inclined.
And Madam Chair, Homicide, for the record, just for a little public comment housekeeping, there was a written public comment submitted. It is posted to the board's website, and the plan would be to attach that to any minutes for a future meeting, but it was submitted in writing, and that's available to view online.
Great. Thank you so much. I am not seeing any hands raised or any public comment. We'll ask one more quick time.
Madam Chair, this is Jared Hickman. If I could make one comment under public comment.
Yes, sir. Please take it away.
I just wanted to inform the board I did attend at least 40 minutes of today's CLE put on by the department on managing expert, and just wanted to comment on the quality of the training and its reiteration in communication of the department's monthly resource forum. I thought it did an excellent job of weaving that, the availability of that resource for practitioners into its narrative. So just a tip of the hat to the department.
Thank you very much. We'll take that all day long. Any other public comment? All right, hearing none, we'll move on to item number 3, which is board-related business. This is for discussion and it is for possible action. We'll start with the approval of the July 9th, 2026 minutes, and I will entertain a motion or comments for changes or additions.
This is
I'll
Chris.
make a
I'd be
motion to
happy to
approve,
make a
Madam
motion.
Chair.
Oops.
Great.
Go ahead,
I
Joni.
have a motion.
No,
by
I'll
Joni
second your motion.
Okay, I have a motion by Chris and a second by Joni. Is there any discussion? Hearing none, all the board members who approve the minutes, please say aye.
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 All right, we'll move right on to the bylaws work group update. So as a reminder, we haven't sent those out, but I think if we can get a verbal overview, that would be great. The board members participating in that work group are board members Joni Eastley, Judge Fairman, Christian Culiani, Judge Maupin, and we have a volunteer, John Lambros. So with that, can we get an overview, please? And I think, Jared, are you going to do that, or?
Yes, I can. Thank you, Chair. Thank you, Madam Chair. I can provide that. The department provided a framework of bylaws for this board. The working group met and reviewed those bylaws and made several potential additions to those. And just as sort of, I guess, by way of explainer, the draft contained roughly 11 sections, covering name, authority, purpose and function, membership, officers, voting, compensation, board staffing, meetings, petitions for action, amendments, and conflicts of interest and ethical obligations. Some of the comments that or potential additions that will be in the revised version that will go to this board for review and consideration and possible revision at the next meeting include orientation of new members, evaluation of the executive director, evaluation of the board, and then some targeted amendments within the bylaws themselves, including how the board handles absences of board members, delegation of certain authority to the executive director, term of the chair and the vice chair, voting, and amendments. So with that, as stated, I think that's sort of a snapshot of what was presented and what was considered and the possible additions that were provided. I think in light of the governor's order pertaining to review of regulations, it might be worthwhile as we consider those at the next meeting to also add a provision regarding routine review of regulations. But we can put that in front of the board at the next meeting. And then again, I anticipate these revisions were not prepared in time for the board's consideration today, but they will be available after the meeting and agendized for the next meeting.
Thank you. And I'll apologize to the members that are trying to follow along. I have like 3 different versions of the agenda that I take notes on in trying to prepare for this meeting. So I realized as I'm looking through this that I was working off of the wrong version. So I ask for your forgiveness as the version that is most current, which is not the one that I have in front of me. Now I do is this item was to be discussed as 7A6. So I beg for your apologies, but thank you for that thorough update, Mr. Hickman. We can continue with this item unless Todd stops me, or we can table our comments until we get to item 7. Mr. Weiss, what would you like me to
This
do?
is Senior Dag Weiss. You can, I mean, it's a discussion item, so if any
Okay,
members have
sorry.
comments about that, we
I'm
can.
trying so hard to be prepared that I'm messing it all up. It's all good. Okay. Board members, questions on the bylaws that we're working on? I know that was just a general overview, and we will have more robust discussion at the next meeting.
This is Chris, and Jared did a good job of recapping. It was a very good meeting. We also set aside some items for future board discussion that not related to the bylaws. So those will either come up under the next section when we take that up and or the next meeting. So it was just for some other legislative matters that might come into play.
I have to agree with Chris. It was an excellent meeting.
Thank you both. Good. All right. Well, I feel like we're evolving as a board with the development of our official bylaws. So we'll get those agendized and make sure we're transparent about everybody being able to take a look and offer their comments at the following meeting. I was actually just testing everyone to make sure you were following along and on the correct agenda. So now we'll go to actual item number 4, which is the Department of Indigent Defense updates. And this is for discussion. So we have 3 parts to this. We're going to do the executive director's update under A, and then B is Deputy Director Roberts is going over training for us, and then C will be Director Sayer with the oversight. So we'll turn it over to you, Mr. Handy.
Thank you. I just realized I didn't get a name in this section. Everyone else did. My principal updates are there recently we went to the Board of Examiners and the Interim Finance Committee. Those meetings went very well. We were seeking funding so that we could ensure that we were able to meet the reimbursement amounts needed to refund the counties that were eligible for being over their maximum contribution amount. In total this year, we'll be reimbursing over $10 million to 14 counties. Esmeralda was within 5,000, I think, which was it's the closest they've ever been to being reimbursed. We really thought they were going to hit the number this year, but maybe next year they'll get there. At this point, we are reimbursing now over 50% of total indigent defense costs in rural Nevada. So the allocation coming from the counties now hits about 48, 49%. The amount we're paying to counties has now exceeded half, which I think kind of better explains or really demonstrates that the state is pulling its weight on being dedicated to ensuring these services are paid for and appropriately rendered. We are asking to build in, we'll be asking to build in at least 13 million to our budget for fiscal year 28 and over 14.5 million for fiscal year 29. And that's going to be based on the budget amounts that the counties have reported in their annual reports. We've either used, depending on the amounts that have been reported, the budgeted amount for fiscal year 27 or if higher, the amount they actually spent in the current fiscal year. There was some discrepancies from a few counties that thought they might spend less next year, and we're just hoping to budget more conservatively and asking for enough funding in case they do have higher expenditures than they have in fiscal year, or than they anticipate to have in fiscal year 27. I want to mention that we have an item coming up on the interim judiciary work session. I believe that's happening on August 25th. It's item G in the recommendations. That does include supporting changes to the NSPD salaries, support for the NSPD to receive social worker support, and funding for meeting spaces where they're needed, in addition to those meeting spaces they already have. Additionally, they are supporting bringing back a new version of creating the post-conviction counsel office. So those are recommendations that, again, are on item G for the interim judiciary work session. Those are based on our presentations last month before the interim judiciary. Go ahead, please.
When is that again?
August 25th.
Thank you.
Let's see. Next, I've got, we've been working with the NAPD. We had our second meeting with them regarding that technical assistance technical assistance. We've been planning, coordinating site visits with them and their team. They have their team mostly assembled. We're trying to schedule out dates, and they're trying to figure out the best way to travel to different parts of Nevada. We've recommended they visit places like Elko, Pahrump, Fallon, Minden, Carson City, and Winnemucca to get a good idea of how things are operating in different parts of the state, operating with different systems in each of the counties, and to get a better idea of where the practitioners are on the ground. We'll be working with them to come up with kind of a liaison for each of those localities, someone to work with, find out where the best places might be to stay, to visit, which local stakeholders would be best to interact with from their perspective. And we'll be reaching out to those folks pretty soon here in the near future. We're hoping that they're looking, I think, at visiting in late October, which should give them both good time to plan from now until then, and also not have to worry about inclement weather later in the year. We also work with them to talk about a nationwide search for the State Public Defender's Office. They receive that well. They've done this in the past for places like Santa Cruz, California, and in a few other states. So they have a lot of experience with this. I did ask, and they are able to provide us with the work product of that nationwide search. So we'd be able to keep the methodology and a lot of the resources that we developed working with them for the nationwide search to then allow the State Public Defender's Office to use for internal hiring in the future. So it's good that we'd be able to keep that information, be able to implement new procedures. For unclassified hiring, it doesn't have to go through the typical lengthy state process for classified hiring, which allows a lot more flexibility in hiring, as some of you already know. But having a gold standard procedure to do that, I think, is a great way to move forward and be able to take that from the NAPD, and their expertise is extremely valuable. I guess I'll go through this one first. As you probably seen, the governor issued another executive order. This one is number 2026-003, requiring a review of existing regulations by all executive branch agencies, departments, boards, and commissions. This looks very familiar to anyone who paid attention to the same order came out 3 years ago, stating almost exactly the same thing. As a department, we don't issue regulations or promulgate regulations. We, of course, can review our own policies to see how things can be streamlined. Of course, the board is the regulating body for this organization. So I kind of leave it to you to determine what the board would like to do in response. In the past, we did receive an exemption. The governor's office understands that because of our obligations pursuant to the consent judgment in Davis, that sometimes more regulation is needed from our department and not less. Of course, this isn't a bad time to go looking at regulations again. Anyways, most of the regulations have hit about a 5-year age mark. So the board may want to take it on the governor's timeline. They might want to take a different timeline. They might want me to seek an exemption. I can do any of these things. I'm happy to help facilitate whatever the board's prerogative is as needed. Lastly, I want to announce, it's not technically finalized yet, but Mark Picker, the former alternate public defender for Washoe County, is engaging in a contract with us to help lead the state public defender's office. He'll be starting, I can't get him in soon enough, but as soon as the contract is finalized, he's obviously an experienced leader. He's got great aspirations for what he thinks the office can look like. He's very motivated in conversations with him. We're very excited that he's going to come on board and to get to work with him. That's all I have for my update. Happy to answer any questions the board might have.
Any questions from the board on anything that?
This is Chris.
Madam Chair.
Sorry, Joni.
Sorry, go ahead, Chris. I'm sorry.
Just not a really smart question, but is the order include anything with regard to Nevada Administrative Code, or is it just solely regulations that are promulgated by a department?
So yes, it includes the regulations end up being codified in the Nevada Administrative Code. So yes, it's any regulations that are promulgated by departments, boards, agencies, etc., commissions. The idea, I think, as it was last time, is to reduce or streamline regulatory schemes for certain agencies. My understanding is it's meant to be more geared toward things like licensing boards to make those processes easier to understand and implement. I don't know, obviously, because I don't work in the governor's office, what the true intent is of any of these things, but that's my understanding. The past one, I don't see it to be any different this time around.
Okay, I thanks for that clarification. Yeah, I think
Yeah.
it is more, it started out more geared towards licensing boards like occupational therapists, massage therapy, and so forth. I just remember back when I served with Mark Amaday and Peggy Carlton, and we tried to actually streamline some of these. So here we are in 2026 having a similar conversation. Oh, well, I'm not surprised.
Joni,
Chris, the more things change, the more they stay the same.
Isn't that the truth?
Uh-huh. And Madam Chair, I did have a question for Peter. Peter, is this something that we should place on an upcoming agenda? Is there a deadline for submitting comments? And then finally, do you think it would be better to have another working group address this and bring something back to the board? Thank you, Madam Chair.
Thank you.
So I think 2 points. To your first question, yes, there is a deadline built into the executive order. I believe it's October 29th, 2026. It's down there in the section 1 after the now therefore. We would need to have it's a workshop session in advance of promulgating regulations. Those require 30 days notice in advance, so that the public can be aware and participate. I think we also have to run a small business impact survey prior to the adoption of any regulations. So I'd ask that Todd do the math on this for me so that I don't have to on the fly. But I think we'd have to start really practically organizing this as soon as possible in order to get it on future agendas for either, for both, I guess, the workshop and then any possible changes or additions to the regulatory scheme.
Yeah, this is Senior DAG Todd Weiss, and I've had this conversation with a few of my board clients already since this executive order came out. The deadline is extremely, the deadlines for turnaround are extremely tight. The reality is it's going to be 2 or 3 public meetings to get done everything that needs to get done before the December timeline for submitting the report to the governor's office. And because the timelines are so tight and because there's so much to get done before then, I don't think a work group in the situation would be overly helpful. I think we're better off just, working through the process through the public meetings as quickly as we can, because we do have to take in the public input. We do have to decide on regulation changes. We do have to decide on a report about the regulation changes. All those things have to be done during public meetings anyway. So I don't think a work group would be overly productive for this, just given how quick we got to turn everything around.
Madam Chair, this is Jared Hickman. May I ask a question?
Sure.
Actually, several. Does the exemption that was obtained the last time this order came out, what was the basis of that? Does it still apply now? And could a potential course of action be to provide the notice required for the public comment and workshops while exploring whether the exemption still applies?
Peter Handy for the record. So my answer to that would be it'd probably be prudent to create the notices and also simultaneously work to see if a new exemption is needed. I would have to ask somebody to find out if that exemption still applies, if it believed it did, or to seek a new exemption. Obviously, that would take some time, along with the notice periods being so short, as both I and the senior DAG Todd Weiss mentioned. I think it'd be prudent to pursue both if that's what the board would like to do.
And if I can interject, this is Masayer for the record. When the last order came out, I was representing a bunch of boards, and what happened shortly thereafter was that instructions about the exemption had come out because people had issues. So we can kind of have our own communication possibly with the governor's office and explore the option, and then also keep an eye out if there's further guidance, because last time it spawned a little bit further guidance about how to make those notices plain.
Was the basis of the prior exemption compliance with the Davis litigation?
Predominantly, yes.
Yeah. So I've got Susan with her hand up, and then Chris G. So can we go to Susan, please? Are those all your questions, Jared? Sorry.
Thank you. You mentioned we have to do a small business notice. I thought when that was created back in the day, it was more in reference to potential tax increases, fee increases, and so forth. This board doesn't really do any of that. So perhaps that's something to add to our list of, should we even be exempt, or let's get rid of that requirement as a suggested.
If I may, Homicide for the record, you're correct, like about the original concept. There's since been a lot of pressure from like local chambers of commerce about being more expansive on that because of unintended consequences or verifying that. So for example, for this board, perhaps that survey would go out to small practice attorneys and just say, hey, this is going on. This might affect your ability to do business or what you expect, since it touches on qualifications and compensation and invoicing and that kind of thing. So since its inception, it's been expanded a great deal to things that don't have a direct financial sort of fee control.
Like Joni said.
Susan, you've been so patient.
Thank you. Peter, I had a question about Mark Pickard. Is he coming on as a consultant to consult and get the Nevada State Public Defender's Office up and running? And is he going to be instrumental in eventually getting a state employee, Nevada State Public Defender recruitment and in place and help with that?
So the answer is yes and no. So he's being brought in under the department's authority to kind of hire as necessary to achieve the aims of the department. Right now, the state public defender position is vacant, and the executive director has the authority to hire somebody in that position. It seems like I also have the authority then to contract to fill that position. It's meant to be a temporary or like an interim basis coverage. It's not just consulting. It's anticipated he may need to represent clients. He will be supervising attorneys in the office. He'll be helping to direct policies and procedures to ensure that the office is really moving in a very different direction than it has been, rather than just providing kind of advice and support. So in that aspect, he's not a consultant. He will be in many ways standing in the shoes of the state public defender. On the latter end, yes, I think he would be. I haven't talked to him specifically about continuing on after the termination of his contract with assisting with recruitment, but he intends to pursue additional recruitment efforts while he's under the contract.
And Homicide, for the record, I met with him yesterday and had informed him about our ancillary contract with the National Association for Public Defense for the National Search, and he volunteered that he thought he would be beneficial in the hiring committee or developing those things. The only thing we'll be careful of, obviously, is that would be possibly on a volunteer basis. You don't necessarily like contract to then do that, but he expressed interest in, being a part of that. And then the national search also would be including, in their last go around, they had 40 applicants. They said that they vetted for another jurisdiction. They got that narrowed down through their processes, and ultimately even had certain applicants come out on site to actually see where they're going to work and that sort of thing. So I was able to talk to him about that yesterday as well. But the official title will be State Public Defender Pro Tem. So he will be effectively operating the office as interim.
And with that, though, because I'm excited he's coming on, I would just rather him be a consultant because I think it's setting a bad precedent for two things. That this is now going to be the expected pay for the next person that comes in as a state public defender, which we know is impossible with the salary caps and if you're making more than anybody else in the state of Nevada on payroll. The other thing is that, so I think that's a problem. And the other problem, so if it's a consultant, I'm fine with the pay and whatever, but I don't want to set us up so when he leaves, we're going to have a problem with hiring. And I believe the state public defender is part of the governor's cabinet, and it's kind of weird to contract somebody for the head of a department as a contract, not an employee. And I want to make sure we're building the state public defender's office as an agency within the state, not with contract employees for all the attorneys. So I just want to make sure we don't put up a position where nobody wants to be an employee of the state of Nevada because they're going to make more money as a contract.
So sure, I think that's why we've really identified this as both being a temporary contract situation, not a contract for employment situation. Second, it's not a cabinet level agency. It's sort of considered sub-cabinet. It's effectively a division of the department, so a subsidiary agency of this department. Yes, there are certainly issues with the salaries that are being paid for the NSPD for a variety of reasons, and we're very hopeful that those are going to increase in the future. And I don't think that it is. I tend to agree with you, right, that contracting for these positions isn't a good long-term solution to providing for a sustainable state public defender's office. But we certainly need the emergent help as it is now, and that's really what we're justifying the higher rate that we're paying Mr. Baker on. And again, all of the experience and expertise that he brings with him to help implement some sweeping changes. So really is kind of performing both role of consultant and filling the role as an attorney directing and leading that office.
And this is Homicide for the record. There's actually a prohibition under state law for contracts against what they call like design build contracts, where you have someone sort of design a concept and then sort of implement it separately. So the established practice is sort of to integrate it. So it's almost like the consulting activity is resulting in instant implementation. The big emergent component that Executive Director Handy is mentioning is really the clients that it's absolutely emergent that the staffing has decreased even since the last meeting of the board. They've lost additional folks and have had other issues come up. So the plan is kind of obviously your point about it being an inherent government function. You cannot contract out an inherent government function, and so we were really careful in the scope to make sure that we weren't doing that. And obviously, the point is well taken about compensation. The sort of time period of the contract is going to be 2 months within a 4-month extension, and it's understood that it's meant to stabilize the office so someone will want to take the position, because you're correct, someone definitely wouldn't take the compensation now if their only option is to come into an office that doesn't have sufficient attorneys, policies, procedures, or a way to sort of right the ship. So the dedication here will be to stabilize the office so that someone can walk in and succeed at the position.
Okay. Chris, you had your hand up?
Yeah, do we have something like a strike team, for lack of a better term, but a wraparound that goes in when you're setting up an office and assists with putting together a lot of the administrative side of that so it's not so overwhelming? I'm just thinking as a first year teacher, as a retired teacher, we would go in and help them set up the classroom, look at what their rules and procedures were. Maybe that would be an assistance that could be provided, just something for food for thought.
And I think that's one of those things that we're considering having the NAPD propose, right? They're the national experts in implementing these kind of systems.
Okay.
They're doing a holistic system review. Part of that would also be recommending policies and procedures, those kinds of implementation practices, right? There should be like a handbook or a binder somewhere so we can run to.
Exactly.
We're setting something up, and we're hoping that they'll be developing those in the future for us. Yes.
All right. Any other board questions on the executive director update report to the board? Director Handy, did you get what you needed on the executive order from the governor from the board?
Yes, I think this is a discussion item only, but I can also, if anybody has any particular direction that they would recommend I take, my plan currently would be to pursue both the noticing the meetings as required along the timeline in the order and simultaneously seeking an exemption.
Okay, so if somebody has a request for future information or topic, we can put that.
Madam Chair, I don't know if anybody else is having this problem. I can't hear you barely at all.
Oh, sorry about
It
that.
is very soft.
There you are.
Is that better?
Thank
Okay,
you.
sorry.
Oh,
I have my
much
little
better. Thank you.
Britney Spears microphone. I had it lowered, so it's not right in my face, but I will move it back up. Sorry about that. All right, I apologize. Let's move on then to our Deputy Director, Brenda. Do you want to give us a training update?
Thank you, Chair. Brenda Roberts for the record. I apologize for being late today. I was in a training today, so that's what was going on there. Our recent trainings we've had since the last board meeting was Professor Rappaport from Boyd Law presented on ethics and billing. That was very well received training, and she brought us some excellent points that overlap with things like attorneys covering for one another at hearings and inadvertently forming attorney-client relationships in those situations. So I think that was interesting for a lot of our folks. Another training was on July 23rd. We had attorney Michael Lasher presenting an appeals nuts and bolts. The training was in response to some oversight reports that we received about appeals issues, and it generated some lively discussion at the end of the training. So that was interesting to listen to at the end. And then today we had a training on managing experts, and that was at noon today. So again, I apologize for being late on that. Our scheduled upcoming trainings, tomorrow is a juvenile competency panel that will be at noon. On September 24th and 25th, we will have an in-person DNA conference that's being put on in conjunction with the Washoe Public Defender's Office and the alternate Public Defender's Office there. And we are making efforts to have that broadcast via Zoom so that folks that are unable to attend in person will be able to watch it live. We are also working on having it recorded so that anyone who can't attend during those times will be able to get the information. October 8th, we have an Ethics of AI CLE. The formal title is quite a bit longer, and you will, of course, receive notification on that as always. Another training news, we are hoping to offer a mental health and substance abuse training later this year, and Helma is kind enough to provide a promising lead on that. I recently attended the NACDL training in Florida on pretrial litigation, met some wonderful speakers, and I'm hoping to be able to bring some of these speakers into our annual conference next year. Our annual conference right now is tentatively scheduled for March 17th, 18th, and 19th in Reno. Once we have the venue secured, we will send out the save the date notices. And we have set our first meeting for the newer attorney training working group, and that's going to be next week. So hopefully at the next board meeting, I'll have some updates on that for you. And then sort of training adjacent are our pipeline efforts, and our annual LASA recruiting event is scheduled for October 15th at noon at Boyd. Judge Westbrook and David Westbrook from the Clark County Public Defender's Office will be the speakers.
Great. Any questions from the board on the training? All right, great job. Sounds like you've been busy. Thank you. We'll move on to Homa with the oversight update.
Thank you, Homa Sayer, for the record. Slightly different approach. I was thinking for the oversight update, You've heard of SWOT, strengths, weaknesses, opportunities, threats. There's a concept called noise, needs, opportunities, improvements, strengths, and exceptions. And so I thought it might be a good way to highlight the positives of what we're seeing in oversight, what we are aware of on the horizon, and what we're doing to address them. Obviously, our needs are, that this is an obligation under statute. It reaches pretty far. It's not just how the attorneys are doing in court and whether they're meeting minimum defense function standards. It also has to do with the counties as a whole meeting their obligations. In statute, for example, really one of the only tools we have is this corrective action planning dynamic. And, whether going forward it's an opportunity to say, we've learned a lot in observing attorneys and their functions to see if we need some intermediate ways that we intervene. We actually do those intermediate sort of soft approaches, but the challenge is that they're not particularly consistently documented, and we'd like to come up with some more policies about that. For example, if there's an emergent oversight concern, for example, yesterday, court staff in one county contacted us and said an attorney was not appearing for court. Obviously, that's a little, something we would do immediately, but it may not result in a training referral to Deputy Director Roberts, and it's not really a county issue. The good thing, or the positive component, is that we have these good relationships that we've developed where people are reaching out not in a complaint posture, but out of genuine concern for clients to make sure that they're being seen. Today, we had a call from a county that was experiencing issues where attorneys are emailing their legal paperwork to the jail, and they're barred from looking at legal mail, and they don't want to be they have no way of printing it without opening it. And so they were able to contact us, and then we can put out some guidance and some things to the attorneys to help them succeed in getting in to meet their clients, what those processes are. So a lot of what we observe or what we hear ends up being an opportunity for education and sort of creating. Derek Lopez, one of our oversight attorneys, had the idea of creating a guide for each county as far as what's unique to them. Okay, in this county, this person drafts, the defense drafts the guilty plea agreement. In this county, it does differently. So if and when we are bringing in out of town attorneys to meet needs, they are set up for success, and they're not making sort of the obvious, I won't say mistakes, but sort of the rookie mistakes that cause possibly a challenge for their clients. So opportunities, we also have, we've signed the scope, and we're embarking on a 10-week actual beta testing demonstration with coding for a new system to replace legal server. The point there being that we do not get the kind of data, the quality of data, the detail of the data that we need to be able to sort of, when counties say, hey, we don't necessarily agree with the workload study about what coverage should look like. If we don't have actual numbers to address that, then we will end up with the same. And we want to be responsive as part of oversight on that. And we actually recently met with the monitor. She said she wasn't going to attend today, but that she's working on her next report will be about September 15th. And, we were able to share through our research about our system sort of gaps we didn't even know we had. So while those would be possibly weaknesses, they're actually just opportunities to address them before they become a problem. For improvements, David Sheik, for example, has gone on his annual leave. He'll be gone for about 3 months. We have plans for coverage for his counties, including we now have new contracted in Nye County mentorship council. You may recall that Mr. Langford previously had sort of an administrator role. We scaled back a little bit on that scope as far as the administrative tasks, and started with, okay, there's 12 attorneys on contract out there. They could really benefit from support and mentorship and assistance in addressing things. So Paul Adris and Steve Baltic are under contract now, and they are super excited to be connecting with the attorneys. They've introduced to the attorneys. The attorneys are excited. And so we're going to help facilitate that support, but then they can also do some of the oversight reporting coverage while Mr. Sheik is out. I will be doing some of it. And then the improvement is that we need more contracts for oversight, so that people can take time off and we're not experiencing a gap in the frequency of observations. I know David Neidert will be out of the country for a couple of weeks, for example. So I want to be more proactive about understanding where people are and getting the in-person coverage. We did have a meeting recently with Josh Foley of Lyon County, and they were reporting really big strides in the physical space. So part of our oversight is examining the physical space. They were able to, I believe it was Fernley, now has ample space for client meetings and for people in the public defense role. And then Dayton Justice Court is supposed to have their rooms ready by like May or April of next year. So that's the other thing that we're doing when we go on site, is we're making sure that there are appropriate spaces for people to meet, and so that they can have that time with their clients. Obviously, our strengths are just our wonderful. We have 3 really great and dedicated attorneys. The idea that we can add more is great. If somebody's listening to this meeting and saying, "Oh, hey, I've kind of gotten out of this space. It might be fun to give back." We have a really straightforward contract. We can kind of make hours for folks, and it will be nice to get maybe some other perspectives, especially since we're feeding this oversight function into the monitor's recommendation for more formal, like annual reviews of attorneys. And then so we've got needs, opportunities, improvements, strengths. Also, our connections are just every time we all are out there or interacting with people, they just get better and better. Vice Chair Hickman mentioned our monthly forums. So what happens on those is in the morning on the first Friday, we have a forum about actual office management, like law practice management, because we find a lot of folks are solo practitioners and they don't have time to worry about certain functions that maybe we could offer them assistance for guidance on: reading contracts, responding to RFPs, getting in that space so that they can do what they do best. And on our recent one, we had an attorney in Las Vegas on, we had a rural attorney. They had never met or talked. They ended up exchanging numbers just by virtue of talking about challenges they were both facing in the court. And that's, I think, kind of that connection and sort of that coffee clutch thing that we want to inspire, even though people are across the state. So that was positive. The afternoon session is what we call our holistic forum, and it's about providing people with sort of more of those social work and state resources. A lot of people don't know how Medicaid works. They, recently we had the question, well, some of my clients don't qualify for Medicaid. Well, then they might not be indigent. So that's a challenge there. You self-report versus a lot of people don't know that when someone is being screened for services, they actually have access. They have agreements with banks across the country to know what money someone actually has, not what they say they have. So people may not be aware of that when they're trying to get their client services. And we can use that information to inform our asks for social workers, our asks for those other things, because we do hear people's frustration. And then finally, for exceptions, it's a topic that definitely I hope we can formulate enough to bring back to the board. What does action look like at different tiers of oversight notice that we get? Obviously, sometimes we get a call and we say, okay, there's a client who left a note in our complaint system. We verify with the attorney that they're in touch with each other. All is pretty much well and they can work together. Do we need to be taking action? What might that action look like? When does it move upward? And then Deputy Director Roberts and I are looking at, what does it look like if somebody needs to come off the list? I understand that someone may just not have cases assigned to them, but I think that does a disservice to the attorney who may have an opportunity for growth if if there's issues with performance, and they should have a right to, look at what's happening. It's not enough, obviously. Sometimes courts and people we get reports about an attorney and they say, oh, they're too zealous. That's actually a gold star moment. We want them to be zealous. That's, that goes on the good side. But if we've got somebody who's struggling and maybe needs lawyers concerned for lawyers or that sort of stuff, like how do we do that in a sensitive way that doesn't put someone on blast, but gets them assistance and, kind of embodies the spirit of what I think indigent defense attorneys are doing for their clients, which is giving people chances. So we're trying to evaluate what that looks like. And then I imagine we'll bring that to the board to lay out at what point do we say, hey, this person met all the requirements in regulation, but it's not doing the trick for clients. So especially since one of the requirements for contracts for counties is that they have to be in good standing on the list with the department. So we're receiving our reports. Like I said, working with oversight folks, we have a more robust overview of what we're seeing with oversights that we would anticipate for the next meeting, time allowing. And again, if there are things you would like us to be looking for when we're out there besides sort of those core defense function standards, we've been taking into consideration things like communication. Our attorneys getting in, we're using their time billing to find out if they're getting in and talking to their clients, because that was a concern that was raised at a prior meeting. So we try to take all of that sort of into the zeitgeist of oversight. So all in all, connections are going well, attorneys are doing well, and when there are hiccups, we're finding out about them either through direct observation or through reports from stakeholders. So thank you.
Thank you. Board questions or comments on the oversight update? All right, hearing none, we will move on to item number 5, which is our Davis litigation update. I know this is for direction and possible action. I know, Peter, you're going to do this because I believe Professor Hanan had a conflict, so she's not able to be here.
Yeah, she's not able to be here today. I just mentioned that we had a brief meeting with Professor Hanan earlier this month and had some conversations about where we're looking to go for workload, how things are currently standing. She anticipates her next report is going to address workload and compliance as of the August 30th date, which is why she's waiting until September to draft and finalize that report. I had conveyed some of the materials have been conveyed to us for assisting her drafting report, including the letter from Mr. Filter, some of the information that we received from folks in Lyon County and in Nye County. Again, things will hopefully change a little bit for the better between now and 10 days from now. But other than that, I don't have much to add for Davis litigation purposes because we don't have a new report yet.
Thank you. Anything any board members want to add?
In terms of compliance, and pardon me, Madam Chair, this is Jared Hickman. In terms of compliance with that August 30th deadline, with respect to the workload, how is that breaking out amongst counties?
Well, that's item 6.
Okay, fair enough.
Leading us right into item 6. Thank you, Mr. Vice Chair. Workload compliance update. Take it away, Jared. Or no, take it away, Peter. You're going to do
Sure,
this.
yeah, happy to. So I guess I'll give you a breakdown of the counties first, and then I'll go back to revisit where we still. I'll say that I don't want to come to any legal conclusions because I'm not litigating this case, right, or managing litigation. I'm just trying to do the best that we are able to meet compliance. So in Churchill County, since the last meeting, there's been no change. There are 6 attorneys. They do have another opening for a 7th. The alternate public defender's office, they're looking to fill. They're confident they'll be able to fill that in pretty short order. There are some interesting questions about Nevada going to the next gen bar exam for timing. It sounds like there seems to be some students can sit in some cases for the upcoming bar or the past bar, I guess, but the next exam period is in December for the next gen bar, causing some delays in students coming out of law school and being admitted to the bar in Nevada. I don't know if that'll affect them or not, but something that we've been made aware of very recently. For Douglas County, I think we circulated the letter from Mr. Filter. I believe there are 7 full-time contracts, unless there's any update from Mr. Filter. Okay, thank you. Appreciate that. They're still shy of the 8.8 for strict compliance. Certainly, there's some number of those that end up being conflict cases for even all of the current contractors. And my understanding is the intention of the county to opt into the state public defender services for appeals and death penalty cases. So that certainly would shift some future burden to the state and away from the county for that representation. For Esmeralda County, there's no change. There's still 1 attorney contracted. For Eureka County, we are assisting Eureka County with creating an RFP or RFQ. Right now, Jane Everett Hardy does have a contract to provide services there, so there's no net change, but they are also contemplating future options, ensuring that they will have continuing services in the event that Ms. Everett Hardy is running in a contested election for a judicial seat. So in case she becomes unavailable to provide those services in the future, the county does have a fallback position. For Lander County, there's no change. They currently have 3 contracts for attorneys. In Lincoln County, there's no change. There are 2 contracted attorneys. In Lyon County, there's no change in the actual contracts themselves. We have had some productive conversations with Cale Brock and, as mentioned before, with Josh Foley and county leadership. They have tentatively agreed to have more conversations. What we think they're going to do is enter into a communication plan. It's going to be a formal communication plan among the county and the attorneys. So that if attorneys join or drop out of law firms, that gets reported back to the county so the county can take action if appropriate on those. And so there's better communication with the county, the department, and the attorneys to understand who's providing services, when and where, identify if there's any potentials for a shortfall in service provision or gaps in coverage for clients.
Will that be limited to just number of attorneys, or will it also apply to qualifications of attorneys within the offices?
So we communicate with the counties anytime there's a change in qualification for any attorneys across the state. But if there is for some reason, somebody comes in and we didn't communicate it for some reason, we typically do, but I think all of the contracts require that the attorneys joining those offices and working in those contracts require those contractors to provide that qualification letter to the county. I think what it's going to do is create a more structured method of communication instead of it just kind of bubbling up from the DA's office or the judges or the sheriff's office or whoever else might be noticing, right, that there may not seem to be enough attorneys or changes in staff, and instead creating both a pipeline for that communication to traverse through, and then to allow for more immediate response. What else do I have? Mineral County, there's no change. There are currently 2 contracts to provide services in Mineral County. In Nye County, there's no change. They still have 12 attorneys. They are beginning solicitation for 432B contractors, so that those won't be a part of the 12 existing contracts. The county had some not unreasonable concerns that they needed to have new attorneys in place before they could take 432B cases away from the current contractors. Obviously, the persons subject to 432B proceedings are also entitled to appointed counsel if they're indigent. So I understand the county wanting to separate those out. It seems reasonable from my perspective, and we are seeing steps to accomplish that, which is really what we were hoping for at this kind of time frame. For White Pine, there are currently 2 deputy public defenders assigned to White Pine, and that's Calder Gabroy and Robert Melsick. And there is a contract for Jane Everhardy to provide overflow support to the office. Jim Hoffman was providing some case supervision and perhaps taking some cases in White Pine County. So it seems at the present there is roughly 3 attorneys providing coverage in White Pine County. Obviously, we prefer them to be more experienced attorneys, have better oversight, and we're hoping that bringing Mark Picker on board will ensure that that's happening. So as kind of mentioned, the three counties principally mentioned by the monitor have been Douglas, Lyon, and interchangeably kind of Nye or White Pine, depending on the report. We're hoping that the change with Mark Picker will fix that White Pine kind of supervision and management problem that's kind of been going on in that county. With Nye, we think the solicitation for adding the 432B contractors separate from the 12 existing contractors should put the current contractors in a place to either have improved performance that is compliant with performance standards, or identify which attorneys that still have those contracts aren't meeting performance standards in the future. And we should be able to work with the county to identify those issues and what potential solutions might be. For Lyon County, as I mentioned, there's also Cale Brock has mentioned he might be working with different attorneys. We told him to let us know if he has any changes. He's trying to seek to employ an attorney in his firm full-time. Also, one of the attorneys he's previously worked with on kind of like one of these independent contractor arrangements has recently applied to be back on our list after previously being removed from the list for not complying with CLE reporting. I anticipate, but I don't know for certain, that this person is likely to work with Cale again, which would bring Cale up to at least 4 identified attorneys he's working with, though the volume's still not immediately discernible. We're working on ways to remedy that through reporting. We've had a few conversations with Cale about how he can get his attorneys to utilize Legal Server in a way that he has access to as the firm and person responsible for all these cases, and to ensure that we can identify if any of these attorneys have too many cases or what the actual workload is they're carrying. Right now, it's difficult to tell since these attorneys also have outside cases they're taking. But we are taking steps to try and remedy that in the way that makes the most sense. Kind of as we talked about earlier, there are some limitations in Legal Server being able to identify where cases are at any particular time. But it turns out that the quarterly reporting we've been doing for Davis compliance is probably the most accurate snapshots over time that we have of where cases are and be able to track them. We did run into an issue, I think we've explained before, where if the case's charges are changed after the initial case is open, it resets the initial charge. So if charges are amended by the prosecutor, or if there's an agreement that would change the charges or results in a dismissal, if those charges are changed anywhere later on by the attorney or their staff managing the legal server case, it changes the original, so we can't track a particular case except in the quarterly reporting, which goes back to why the quarterly reporting from the attorneys is so important to us having the most accurate data we can in the interim. I got a little field for Lyon County, but I thought it was good to explain. Hopefully, everybody better understands why we're trying to work with Kale to get better reporting rather than just getting these kind of independent contractor agreements. Because to me, that's not quite enough to demonstrate that he really has the ability to provide up to 5 attorneys in Lyon County. I think that's been some of the monitor's chief concern.
All right, thank you. Board
Happy to answer any questions.
Yep. Questions on compliance. All right. Great job. Let's move on to number 7, board and advice and recommendations on our NRS 180. This is for discussion and possible action. We have all the items that we've previously discussed. There are 6 of them listed here. Do we want to just run through those and see if we've got updates or additional direction needed from the board?
Sure, I'm happy to. So let's start with A1, if that's all right, Chair.
Please.
All right, I think we've run over the State Public Defender's Office current circumstances a little bit. We did lose a legal secretary who was working in White Pine County. She resigned fairly abruptly. So we are having some of the staff in Carson City help provide support to the extent they can. But there is both a staff shortage in that office now, as well as an attorney shortage. New staff did join the office working in Winnemucca, but they're very new to the agency, haven't had a lot of time to train or onboard. So the ability to really bring up the make up the difference for the law staff is difficult. That's going to take some time. And again, very hopeful that Mark's experience will come in a great value to help write the office. I can answer any questions, or I can move on and ask questions at the end at the chair's kind of choice here.
Yeah, go for it. And if people have questions, please raise your hand or chime in.
Rural stakeholder meetings, we haven't had a chance.
Peter, this is Judge Fairman. With reference to the on-site staffing shortage in White Pine County, are we looking at a particular standard to have someone just be in the office as far as a certain level? And if so, I mean, can that be augmented just so that somebody is there, okay, that can answer the phone, knows the telephone numbers of the lawyers, just sort of a friendly face that, when you have persons that can come in the office, that they can see that there is somebody there, and that this person, has enough skill through, the interview process to be able to relay messages, and can experience some training as they go along. And that might be something, if I don't know if you can call it an emergent situation, it's sort of one that we might want to look at for the time being. With obviously the gold standard probably be what the state minimums are, okay? But maybe pending getting the gold standard, that might be something that we might want to look at if possible.
Yes, so we actually have been working with DHRM to solicit for that for a legal secretary position to be situated in Ely. We ran into the bureaucracy problem. We tried posting it at the standard. We have to post it at the rate that it's classified at, which is a legal secretary 2 position, before we could then try to underfill at lower position levels. So at this point, I think the first one has run. We've already asked them to then rerun it as a underfill as either a legal secretary 1 or a legal secretary trainee position, so that we can get somebody who doesn't have the experience requirements to make it through the filters with DHRM, so we can get somebody in the office. We already have some good recommendations of people who might be available from people in the community, but we still have to go through the standardized classified process. We can't go outside that. Even the only way we can kind of go outside of the standardized process is for things like temporary employees. And even that is not much faster than working with DHRM. We have worked with them to expedite turnarounds for application windows, so 7-day windows for applicants instead of 21 or 30 days, so we can try and get that that position recruitment open to more eligible applicants as soon as possible. It seems like that should occur in the next couple of weeks, hopefully, that we get down to a level where we're getting applicants that are actually able to make it through the screening. We're hopeful.
And almost there for the record, I forgot to mention that the monitor did go in person and meet with members of the judiciary in White Pine County, and imagine some of that will make it into her next report. But also the contract with Mr. Picker includes contemplation of either being on site in one of 3 locations: the Carson City office, the White Pine office, or the Humboldt office at any given point. And he understood the importance of being present and being on site there. And the offers we've had in the community were people who could come in person and be that friendly face. But we wanted to obviously follow this part of the process and make sure that we might be then ready with onboarding, so that they're getting all the information they need. And then regarding concerns from the court, this is related to oversight, concerns from the court about being able to reach people at the State Public Defender's Office, we were able to identify that that there was an issue of someone's voicemail being limited to 20 messages and it was filling up instantly. And so we're trying to get the entire office moved to something that would better suit them, including generating text transcripts of messages that will be emailed so that it'll reach them at any point. But then when there's people in person answering the phones, starting to have that be the number people call and then get directed to. So that's absolutely something that the judges have mentioned. The ability to get a hold of someone to quickly put a hearing on or what have you, it's a challenge, and it shouldn't be.
Madam Chair, may I ask this is Jared Hickman. May I ask a couple of follow-up questions?
Of course.
Did anyone from the department participate in the with the monitor in the judicial conversation in White Pine?
Homicide, for the record, we helped coordinate the scheduling. We offered to be there. She did not prefer that we be there. Mr. Sheik offered a date and a time where he could be there, and that she could also possibly observe court at another location. And she worked with a time that worked for her and the judges, but we did offer, and she said that it was a productive visit, but we wanted to make sure if there were questions of us, we were available, but it was declined.
And then going back to Judge Fairman's points regarding person in the office, a couple of meetings ago we had Ms. Everhardy make comments pertaining to I guess sort of the state of representation in White Pine County, and one of the concerns was two of the concerns were staffing in the office among the attorneys, and then the ability of incarcerated clients to reach attorneys in the office. And I just wanted to see if those issues had been addressed and followed up on. Are the attorneys in the office regularly, and is there a number that clients can reach their attorneys on in the office?
Yes, that's part of what we've been addressing with them. Again, it sounds like what we're told, because I haven't been down to see how the systems are actually operating, that there's some limitations that are technical in nature with the way they're using state phone systems. We've already started offering some solutions about how they can remedy those situations. We've recommended in the past centralizing a number that's going to be available, but that hasn't materialized or doesn't seem to have materialized yet. We expect it should be something that is happening fairly soon, though. Even without having somebody in the office, there should be no reason that a client can't just get a number that a person answers and then directs their call appropriately.
And homicide, for the record, we also learned that it's not part of their protocol for if staff do receive contact from clients that are not attorneys, they're not tracking that. And that's of concern, because when someone says, oh, I haven't been able to reach anyone, it would be lovely to say, oh, well, here's what the status is, not to counter it, but just to make sure we're not missing anything with that, sort of that centralized contact piece. So that was, and then also Jane Everhardy was one of the sources for a potential staff member, because one of the recommendations she had made was underfill and then train somebody. These are tasks that can be taught. And so we want to make sure that that's happening. But since we've got Mr. Picker possibly starting the next couple of days, then we will be doing that jointly and encouraging folks to apply.
Please proceed, Mr.
I'll
Handy.
move on to number 2. Thank you, Madam Chair. Rural stakeholder meetings. We haven't had a chance to start developing out rural stakeholder meetings. We do, I think I have it scheduled somewhere. I do have a presentation I've agreed to do for NACO on September 22nd, just to give NACO members an idea of what the department does, how we interface with the counties, how we interface with the judges, how we're different from all of these entities, and the kind of support we provide. The amount of time we have to give that presentation is actually more limited than I thought it was going to be, but my intention is to kind of stick around and meet the members and get to know them on a more personal level, try and understand what their needs are, and let them know the communication is always available through us if they need anything and aren't aware that we're somebody they can get a hold of.
Is that presentation at their annual conference?
Yes.
I should be there with you.
Oh, great. If there are any questions about that, or I can move on. It is still our intention to coordinate and hold rural stakeholder meetings, but the focus, obviously, I think, has been the meeting the workload standard in the last month and trying to keep the NSPD in better shape than it otherwise could be in. So third, remote appearance work group. I don't know if any of the members of the board were still interested. I hope they are. And setting up a work group to recommend remote appearance standards. I don't know if the board wants to do it by way of regulation or just recommendations to our department to implement as guidelines or as standards performance. It could be something that the department, or that it is something that the monitor has recommended multiple times, that some standards be developed. It would be obviously great assistance to us if the board members' experience in this area had some recommendations that either we could adopt or that the board could resolve to adopt more generally that we can then start implementing.
Peter, I wanted to be on that committee. Susan Bush, sorry.
Other board members interested in serving on the remote appearance standards development work group? Joni? Okay.
Yeah, sure.
Thank you.
Madam Chair, Commissioner Blakey would like to be there.
Thank you.
Great.
And this is Homicide. This might be a good time for SDAG Todd Weiss to give possibly some guidance on, obviously we have these meetings and folks say, I'm interested. We want to make sure that maybe you select somebody who's like the main point of contact, or make sure that we can facilitate, the follow-up on it. I don't know, Senior Doug Weiss, if you want to address kind of your thoughts about work groups, about the number of them and their composition.
Well, I'm a big OML guy. That's what I'm mainly here for. So work groups kind of give me uneasiness sometimes because it's very easy to, no pun intended, walk into a walking quorum situation, especially the more members of the body that are on it. Because, as you know, we can go right up to the point of quorum. For a work group, and that's totally fine. But the second one person from that quorum talks to one person from that work group talks to somebody who's not in the work group, we've now exceeded quorum and now we've violated the open meeting law. So, whatever work groups we put together, just please keep that in mind. Please keep in mind that we have to limit it to the members that, we say here, are volunteering and are going to be in the work group. We cannot bring in people or other members that are not in that work group from the outside. And nobody from the work group can talk to other members from the outside of the public meeting space. We have to adhere to these standards. I know it doesn't make things, easy, more simple in the collaborative aspect of everything, but we have to adhere to OML, and that is a primary concern. So please keep that in mind, that with any of these work groups that we create, it has to be limited to just that. We cannot willy-nilly add other members, bring other members in, or we will violate open meeting law intentionally, and no one knows what kind of problems that could create. So let's just make sure that we keep them to the members that we are saying we're going to be in them, and no others.
Thank you. I'm clear for the record. So that was a dovetail into in the minutes right now. For example, when something is moved, seconded, voted on, it has a structure. What we can do for work groups when they do come up is indicate who volunteered, and then as far as action items for the department, are we being asked to sort of kick it off by connecting those people? Or is the board maybe selecting sort of a chair of that work group, and then that person will coordinate? We just want to make sure that if people need support from us, we are able to give it. But if the work group is off doing their thing and is just going to report back when they're ready to provide an update, I don't know what the pleasure of the board is on that. So, for example, my notes reflect the three members who would be tackling this. But as far as is the department trying to make sure that we coordinate that they meet, or are they coordinating amongst each other, or what does that look like, so that we aren't dropping the ball if something is expected of us?
Susan has her hand up. I don't know if Board Member Bush, do you want to comment on that?
Yes, thank you, Chair. Well, I wanted to ask if a board member could be part of, one of the DIDS directors could be part of the work group. And if we could consult with the oversight attorneys, or would that be not available as part of the work group?
Almost there for the record, the practical issue of, for example, the oversight attorneys taking now as their vacation time would possibly delay your work group because they won't be available. But I would say that what we could do is, if the work group needs information, think of it as a public records request, right? There, at any time, you could ask the department, I'd like to see some information about this, or I'd like to see some information about that. I think that's totally appropriate, because those are records. If you'd like to have an oversight attorney on the work group, it seems like that might work if we make a record of it, and then whichever one might be available or willing could, we could then fill in that name. I don't know if any of them are on and have thoughts about that, but as far as department support, this is where sometimes it feels stilted, and it's our goal not to be a barrier, but we're just trying to follow our rules. And if we're involved, then also there's some public record components too, because we have to maintain those records for things that we're participating in. So I think we could be available on a sort of resource basis, but I'll let Executive Director Handy speak to that. I just don't know if we would be on the work group as far as just providing information.
And I think, just to Taylor, part of my issue, I just wanted someone, I know that the oversight attorneys know what the current practice is, that certain judges don't allow remote, certain judges do allow remote appearances. And that would just be really helpful to start with that knowledge already.
Yeah, so Peter, Peter Handy for, I think we can certainly do that. I obviously don't want to compel any of our oversight folks to do it in case they're on vacation. They are just independent contractors. I'm sure they'd be more than interested in helping out, though, and providing information about what they're seeing from county to county, what might make the most sense, while you're trying to develop a standard that they're going to then be overseeing.
This is Jared.
Oh, sorry. Mr. Weiss, do you have anything to add? Then Jared will get to you.
Thank you.
No, I have nothing to add, Madam Chair.
Okay, thank you. Go ahead, Jared.
Thank you. A question for the department, perhaps Dag Weiss and also Ms. Bush as well. Do you think it would be advisable, in addition to perhaps the oversight attorneys, but also to get perhaps county indigent defense coordinators or other practitioners to provide input for this group on possible standards that come out of it?
Peter, from a departmental perspective,
I'll just add my quick piece, Peter, and I'll let you take it. Because from an OML perspective, which is the only way I'm looking at it, because the rest of it is policy and strategy, which I will leave to the smarter people in the room. OML wise, you could add as many non-members to the working group as you see fit. I mean, I wouldn't advise it for efficiency reasons, but if you want 100 non-members to be in the working group, so be it. It's totally whoever you think has the expertise that you would find helpful, and there's no OML issues with non-members. It's strictly members of the body being part of the working group, and then I'll leave the rest of it to Homa and Peter.
Yeah, so Peter Haney, for the record, I think it's a great idea bringing in indigent defense coordinators, public defenders, contractors to get different perspectives for this working group. I think that would be very valuable and useful for both the working group to develop, again, ideas for the board to consider as policy, and then also ultimately for us to be able to it has a lot more utility if we have a lot more points of view that have been taken into account when we're trying to implement these kind of standards.
And homicide, for the record, there are ways you can do that in a novel way. For example, is you have your core work group, and then maybe you assign and say, okay, member Bush, you're going to call the oversight attorneys and do some research and then report back to the group. So there's ways to do it without necessarily having them sit in on every meeting or that kind of thing. And then if you get to the point where you've formulated some options, then it may be perfect to come back to the board for some interim instruction. So I did definitely, the oversight attorneys can participate, but they are compensated on contract, and then they have their own availability. So it might be best to have them sort of be guest stars in the work group when you need them, or even you want to verify some information, versus having them be assigned.
That makes sense, and it clarified a lot of information for me of how to get information and not violate the open meeting laws. Thank you.
All right.
Chair, this is Gary Fairman.
Go ahead, Judge Fairman.
I would also volunteer to be on that committee if we're not getting close to quorum issues.
According to my list, that is 4 board members and still short of the 7 that would be required for a quorum.
Great. Okay. Thank you. We've got our 4 volunteers for the remote appearance work group. I think, unless there are other questions, we have a few more items to crank through on this item number 7A if you want to continue.
Yes, let's go to, where was I?
On 4. Yeah, attorney-client communication.
Yeah, security frequent access. So I think we kind of addressed this earlier that we have been working about with attorneys about being able to access, communicate with their clients. We have productive conversations with a jail. We have ongoing communications with the prisons about, I'm still curious to see when they're going to whitelist emails. They haven't let me know if they have a date certain yet, but they've provided processes. It's actually become interestingly apparent. Like, we've done a little bit of research, like, how to communicate with the jails. I think every county jail we looked at has some sort of kind of contact information that would be a good starting point. And we can certainly repost that in kind of a more centralized place on our website as a resource for attorneys to look at. The jails that we've spoken to in the past have been, of course, it's us speaking to them, not somebody else on the ground, right? They've been fairly willing to accommodate. They, of course, always mention that they have staffing issues, and obviously they can't be everywhere at once or working at different facilities at the same time due to those staffing restrictions. I think the attorneys generally are sensitive and understanding of that, so long as it doesn't get in the way of them actually meeting their clients. But we are working with them to try and create more efficient ways for attorneys to have meetings with their clients. Ultimately, right, the standard is that they meet with their client in person within 1 week of receiving that person's case. If that can't be met, obviously any meeting's better than no meeting. So it might be the case that they are visiting virtually or having some intermediary within their office go visit, like a coworker or staff. And while it's, again, not meeting the standard pursuant to the ADA offense function standards, it's, again, certainly better than no meeting in advance of an initial appearance, arraignment, or whatever might be coming next. So we're trying to bridge that gap to the extent we can in the best way, or to at least make more knowledge available, more information available, so that attorneys can engage with the offices more easily.
And homicide, for the record, one thing we had contact from the Elko Public Defender's Office saying that when people can't reach their attorneys, they're contacting the Public Defender's Office, even though they were conflict cases or what have you.
Yeah.
So one of our planned solutions is that right now when selection opportunity emails go out, the goal would be to say you are not eligible to accept this opportunity unless your number is on file, with the facility, yes, so that you can be reached. And then similarly, include other important information so that hopefully it's a reminder by county. For example, in Humboldt, the message would also include, they need 12 hours notice to have an in-person visit. Here's how to do a Zoom request. Just eliminate any barriers that a busy person might have to following up or reaching out to someone who's in custody.
Okay.
All right.
Any questions? No? Questions on communication? Time. I know I gave this to you, Peter, so I'll let you have it. Actually,
No
I'll
worries.
step up.
You always have the talking stick, Madam Chair.
I don't want it.
Number 5, the list of counties with e-filing systems. I think we mentioned this last time. It's a moving target in some ways, in that there's some counties where the courts actually have different filing systems from other courts, while some district courts might have e-filing systems, and jurisdictions, justice courts or community courts don't always. We are seeing still there's growth in counties developing their e-filing systems. Some are having hiccups with accessibility or with data availability that they're working to overcome. If at some point we're able to get a very clear list of courts with e-filing systems, we'll be sure to get that out to the board and the membership and the attorneys we're working with, just because we know that working in counties without e-filing systems is difficult and expensive and time consuming, and also let them know whether there are courts that are willing to, I won't say bend the rules, but accommodate their lack of an e-filing system through use of email or some other method. I'm happy to answer any questions if there are any on item 5. I don't see a hand raised, but I don't know if I'd see it on my screen. Okay, great. So moving on to 6, a bylaws work group update. We sort of hit that off at the beginning. I don't know if there was anything anyone wanted to add or discuss.
This is Jared Hickman. I don't have anything to add other than to echo Ms. Easley and Ms. June Kiliani's comments that it was a very productive meeting. And also, as Ms. also as Chris said, we had some legislative talking points that came out of that, which I think is the next item on the list. And at this point, I'll defer to anyone else part of that working group that has comments that they would like to include in the record.
Jared, I just have one question. Do you plan on having us meet again? Are we going to go through a round 2 when the recommended additions and changes have been prepared?
They are prepared and they are with the department right now. Joni, my thought would be that we get a comment from the full board and public before we sit to revise them further. All the comments that were discussed at our last meeting were wrapped into the revision of the starting point. So at this point, I think it would be beneficial to hear from other board members and the public before we sit down to revise again.
I'm good with that. Thank you.
And for the record, Homa Sayar, in keeping with the idea of how to organize the way we put work groups in the minutes, could Vice Chair Hickman just put on the record who's a member of that work group, and then we'll block that out when we do these minutes just to make sure it matches where so if someone were skimming minutes, they would be able to see who's a member, because we didn't really have a plan the last time, and I think that may have caused some confusion.
Okay.
Great. Okay, well, that brings us to 7B. These are the board member requests. This is where we talk about legislative priorities, and I know we talked about this with the bylaws work group, so I don't know, Mr. Handy, if you want to go into detail about that, or
Madam Chair, if I could punt that to somebody who knows better than I do, since I wasn't a member of the work group.
Yep. And we covered it, I know, early, and we listed all the things that were in the bylaws. But Jared, anything else you want to add on that? It's a decently robust agenda item.
It is decently robust, and I will say that these were, although the working group convened on the bylaws, these were points that came up in the context of the bylaws that were decided by the working group to be outside of the scope of bylaws, and we thought the best method of dealing with these were to place them on the agenda for discussion with the entire board as to what legislative priorities may be or should be for the board. And I understand after talking with both Peter and Homa that we may have some constraints with respect to timing, but in terms of getting board discussion on what legislative priorities should be, we provide this list that came out of that working group. The first, expanding board membership or qualifications, to include more criminal defense lawyers or persons with criminal defense experience. And obviously, not obviously, but that is in an effort to be able to better assist the department with that background and, more, I guess, sort of on the ground relationship with practitioners that are working with both the board and the department. Two would be to remove the gubernatorial ratification of appointments once an appointing authority has made its decision. And the converse of that is removing the governor's role in removal. As of now, if we have, if there's a board member that just say is never appears for a meeting or something like that, in order to remove that person, we would have to get the governor's approval on that, and then same with the ratification. So the thought was in keeping with the independence of the public defense function, perhaps those roles should also be removed. State public defender restructuring and pay parity. And I think this falls in line with sort of, I can't remember if it was Peter or Homa's thoughts, but just sort of that long-term mission vision planning as to what the state public defender should look like going forward. Is it a, sort of a SWAT team that comes in when there is an issue within a county that needs assistance? Is it just strictly a post-conviction and appellate office, or is it something more akin to a traditional office? Pay parity we discussed, and it sounds like that's at least initially set for August 25th with the interim judiciary work session, and then that was previously discussed in April or May in a meeting with the governor's office pertaining to the state public defender's office. And then the length of the chair and vice chair term. I think the statute currently right now only speaks to 1 year for the chair. The idea behind it, also from Chris G, was that in order to promote consistency and internal knowledge, it would be worthwhile to have that position serve longer than a year. And again, these are just sort of starting points. I'll turn it over to the department for where we stand in terms of our timing for BDRs or other avenues forward, if there's anything that the department wants to ensure it hits for the next legislative session.
And Peter Handy for the record. I principally want to hit on the item 4. I won't talk about restructuring, but pay parity. We do have a proposed fiscal BDR that would legislate into the statute that the state public defender salaries would be the match to the average of the 2 highest paying county salaries for similarly situated positions. It was created for that way in case for some reason some county decides to change their rates. Right now it's Washoe and Clark, but Carson City, for example, isn't far behind on their pay scales for public defenders. We changed the recommendation. Initially, we considered doing something we recommend pass or proposing the pass, which is to have parity with the Attorney General's office. But that's also wildly inconsistent with what other agencies are paying. And I think, as I mentioned at the interim Judiciary Committee meeting, like the work that's being done by rural public defenders is no less valuable than those being performed in Washoe and Clark County. Right? So that's our proposal. We'd hope for that continues to get support through the session. Obviously, we don't have any control after these things, after they kind of hit the mix, which is where everything's at now. It all kind of goes into a bucket that we don't see again. And then also, if we do end up with some draft language, can't talk about again until things are on the floor and made public. I don't have any other input on the remaining items. I'm happy to assist the board to the extent I'm able. As you mentioned, we discussed previously, like our ability to submit BDRs for policy expired in April. Those are required to be submitted very early on, and for fiscal BDRs, those expired, last Friday. So recently, but I don't think many of these are likely to actually have fiscal impact, except for maybe for So I'm happy to answer any questions about any of these ideas. I think this is a great start to either the board, if they want individual members, or the board wants to write a letter or have the chair pen a letter to legislators or the legislature or the governor's office. This is a great kind of set of things to talk about. I think if for some reason these don't surface in the next legislative session, something to bring up in later sessions as we look to more future improvements to the system.
Yes,
Right.
Peter, this is Ben Goman. I had a question as it pertains to number 2 and 3. I guess I would need some perhaps more explanation on whether this is an issue where we're saying at its inception it was perhaps less than ideal to have the governor have so much power versus is this now an issue for 2026 where we need it? I would perhaps need some more guidance on that.
I'd probably punt that to the working group. My understanding is that the board members and the board composition and how they were appointed or removed was part of the more detailed negotiations as a result of the Davis consent judgment. That this is the language that was proposed that was required to be adopted by the state in AB 81 as part of that judgment. I imagine that circumstances have changed sufficiently from 2018, 2019 that this might not reflect the best situation, but I can't personally opine as to what, how this was come to or agreed upon or why the current method was recommended. I do know that it was major part of the point of negotiation.
Thank you.
And this is Jared Hickman. If John Lambros is on, I would also defer to him as part of the original Indigent Defense Commission that created AB 81. But just in terms of dates, AB 81 was passed in 2019, I think, before the Davis consent judgment. And so this language was part of that original bill. And after, this is sort of a move to bring consistency within the statute after the termination of the prior executive director. That language was modified to remove the governor's, ability to summarily terminate or terminate without cause. And so this would be sort of in one sense, a conforming change to remove that, governor power from board selection and removal as well. But if any of the other members of the working group want to join in, particularly John, if he's on, I think he provided some insight as well.
Or Franny Forsman's here.
Yep.
Yep. Mr. Lambros, would you like to chime in on that?
Sure. I didn't know if it was appropriate for me to, but I'd be more than happy to. First of all, before I do, I just want to thank the folks that worked on that working group with regard to the bylaws and to the future legislation. I thought it was a great couple of hour meeting, and I hope that it does help to inform the board. In any event, with regard to the recommendation concerning the governor, rather than bore you all with the history of AB 81 and why the governor had such prominence in that legislation, if I could go back in time, I think what I would advocate that the current iteration of Chapter 180 did not include the governor in any way other than one appointment. And I think Marcy's termination is the prime example of that. The governor's termination of Marcy was cutting off his nose to spite his face. In order to come into Davis compliance, as I said in my public comments at the last board meeting, this organization is pivotal. DIDS is the linchpin for Davis compliance. The governor's office cannot comply. The governor needs DIDS to be prominent with regard to compliance. So to me, it's really, it's other than having DIDS do this, I didn't see any need, and this is just my opinion, to have the governor involved other than to have one appointment on the board. So that and I was going to make this recommendation in public comment, and just so this doesn't sound like a outlandishly progressive stance. It is consistent with the theme of the most recent Davis amended judgment and stipulation that was filed last in August of 2025, where the state public defender's office was taken out of the control of the governor's office and put in the exclusive control of DIDS. And what the new legislation says, as well as that amendment, is that it was done in an effort to free this board from from the executive department. And if you look at the current iteration of Chapter 180 when it comes to the state public defender, the last sentence in there, and I don't have it in front of me, talks about the need for the state public defender and this board, by extension, remember that they need to come into full compliance with the ABA standards for criminal representation of indigent clients. So that's why I think that this would be not only a smart move, but one that really is begged by necessity. And finally, my only other iteration, or not iteration, but extension of that, I don't have my fellow working group members on board with me here, but the other thing, and I was going to mention this in public comment, but since I have the floor, I think it would be a good idea for this board to consider taking the appointment, retention, and or removal of the executive director out of the governor's hands. I think that that position should be exclusively under the complete control of this board. If Peter were to resign, the board would be left with the unfortunate, or I say unfortunate, because I think Peter's doing such a great job, circumstance of having to select three candidates that the governor would choose from. I don't think that that's fair to the board. This board knows who the best executive director would be, and I think that this board's institutional memory of that uh, must definitely lead to the conclusion that the governor should not be involved in that process as well. So that, and just one final word on the state public defender's office. Peter, I didn't know how many positions you were asking for, but I was hoping it was going to be somewhere between 7 and 10 positions to fill the needs that you're going to have for not only Nye County, but Humboldt County, and God forbid, any event that may occur in a corrective action plan, or if one of the counties that are currently using a contract system wants to opt into the state public defender system. If that were to happen today, and this is no disrespect to the board, the department, or the state public defender's office, if that were to happen today, I don't think the state public defender's office would be able to handle another county. Pardon me. They haven't even been able to handle Humboldt County. So anyway, I apologize if I've taken too much time. I hope that this has been informative. I think the working group and any other working groups that this board can look to within the constraints of the open meeting law can really help to serve to inform forward progress and, most importantly, Davis compliance. Thank you, Madam Chair.
Thank you, Mr. Lambros. Okay, other questions or comments on the legislative priorities discussion and sort of the history of how this came about and some of the suggestions from the working group?
Homicide, for the record, just since budgeting came up, just for the board's benefit, what the department asks for in budget, we call it GovRec. It has to be private until the state of the state. So unfortunately, we can't address specifically the inquiry from Mr. Lambros about those plans. But the reason being, that it's confidential and we can't even really reveal what we asked for in relation to what is given.
Okay, thank you. I certainly appreciated the history, and the input. Okay, if we're comfortable moving forward to item 7.
Madam Chair, I have some
go ahead,
comments.
Mr. Blakey. Yeah.
I guess the board members have a chance to comment on each of these items. I would just say on item number 1, I feel like the amount of people on the board at this time is a good amount, and I think the county representation is the correct amount due to our financial obligation that we have. Like as our obligation goes away, then maybe the county representation could maybe go down lower, maybe. I think that we are in a good position with the board. Item number 2, I think it should remain. Item number 3, I think it should remain. And item number 4, definitely Peter seems to have a good take on what he needs to do there to get that in our right direction. So I fully support his ideas there. And then item 5, I think it's a great idea to do a 2-year term. And then we sort of proven that this year because you're on your second term already, which has been vital. As new people come on and off, it was for me. It really brought some security there. So anyway, that's my comments on that item. Thank you.
Thank you, Mr. Blakey. Okay, other board member comments?
Madam Chair, Susan Bush, can I speak?
Go ahead, Susan. Yeah.
Yeah, I just wanted to say I completely agree with Mr. Blakely on his assessment of the items that were brought up.
Thank you. Other board member comments? All right, hearing none now, we will move on to 7B2, which is the Performance Standards Work Group.
And I know we talked about this previously. This addresses the monitor's concern that the board hasn't promulgated other performance standards outside of just adopting the ABA defense function standards. I think that actually kind of feeds into HOMA's kind of inquiry about how do we proceed given a certain violation of a particular standard. We've contemplated in-house things like kind of just going through the entirety of the ABA defense function standards and kind of scoring them up about how would a violation of any particular standard be treated, how would repeat violations be treated. And that's in part to create uniformity so that we're not unevenly applying a response to something that's brought up about a particular attorney's performance, and a way to help inform that annual review process that we're trying to get off the ground. But it would really be helpful to get NAPD's input before we start implementing that in its entirety. But again, having at least, even if it doesn't get adopted as a regulation, some support from the board as a work group or in total to provide some input on performance standards, I think would be helpful for both our agency and for assisting the monitor in identifying data.
Okay.
And I don't know if the board wants to do that now or wait until other work groups have closed. I know it can be a lot of extra effort, especially for the board members on multiple work groups to dedicate the time, resources, energy to multiple things at the same time.
Madam Chair, this is Jared Hickman. Just a quick question. Will part of the contract with NAPD be to address performance standards for attorneys, or is that not part of that agreement?
Performance standards generally are not. How we implement those standards would be. Does that hope that answers your question? So the oversight function we perform is something that's within the scope. It's arguably probably within the text of the scope for them to address those. So we could probably request that they provide some support, or I'm sure they have plenty of resources for work group members or the department to try and dive into if that's something that we'd be looking into.
And that was my thought, is it might be a good they might be a good resource, or at least have the ability to pull in resources, and then along with not that I'm volunteering anyone or making any suggestions, but appointed council administrator Ms. Bush might be a good resource, as might Mr. Filter, and the oversight attorneys, frankly, and in helping develop those standards.
And Ms. Bush, I would be happy to serve on this committee and help in any way.
What's the pleasure of the board from a timing perspective? Do we want to wrap up other work groups and then work on this? Do we want to do them in parallel? I don't want to overburden everybody, but
Again, Jared Hickman, I would be happy to join this committee as well. I would like to get the bylaws settled first.
great. I was thinking the same, but I can be talked out of it if others are very, very wanting to get working on this. So if that sounds like a good course of action, Director Handy will wrap up the bylaws and then initiate this performance standards work group. Does that sound good to the board?
Yes.
I'm
Yes.
not hearing
Yeah,
anyone
it does.
against.
It sounds good.
Thank you. Okay. I didn't take a formal vote, but Mr. Weiss, if you want me to, I certainly could. No. All right, good. Thank you all.
Great.
Let's move on to the bids legislative tracking work group.
Yes, and this was recommended by board member Easley. She gave me a call. I think it's a good idea for the board, or it could be a board member. We usually solicit to see if we can get an extern from Boyd for the legislative session. That's somebody we could have work with this work group. While Nellis is an interesting, useful tool in many ways, it's not always the most accurate tracking tool for legislation, as some of the board members may know. So certainly having somebody on the board that's familiar with the legislative process, with legislators, or who has the availability would be of assistance, I'm sure, to the rest of the board and to the department to help kind of identify things that are moving or not moving, as might be the case. And perhaps Ms. Easley has more she wants to discuss on that right now.
Joni, do you want to give some more input on that?
No, I think Peter covered it.
Okay. Then do we have recommendations for folks? Do we want to wait to the next board meeting as we get closer to the ledge session? I'm happy to entertain volunteers now.
This is Chris. I'm happy to help if
Thank you, Chris.
on timing. I just have a question for next week. There's a work session on judiciary, and I noticed that indigent defense is on that work session doc, but nothing, I haven't been able to pull anything up. Are we monitoring that, Peter, or?
Yes,
know?
we're in item G on that agenda.
Oh, I'm sorry.
Yeah. No worries.
And Homicide, for the record, the legislature has now placed work session documents behind a password wall, so you have to re-register for your Nellis account. And if you haven't since their update, and you have to be logged in order to access any attachments. So I was able to access it, and I can actually just email it to you right now to make it easy. But that's probably the reason.
That's why I couldn't get in. Okay. All right.
All right.
And Madam Chair, I always welcome an opportunity to work with Chris, so I'll volunteer for that.
Okay. Thank you. Any others interested in the legislative tracking?
I don't want to be on the committee, but Susan Bush with Clark County, sorry.
There you go.
But I do track with Clark County, and we have a great program. So I'm good sharing the bills with them and the information. I think I shared last time with the department the information I had as we tracked it.
Great. Thank you.
That would be very helpful because it isn't always navigable. So
Good.
And if the board members look at the in every issue of our newsletter, aptly titled "Did You Know?" but I'm changed. It includes our latest legislative tracking, where obviously it'll be broader. There's a lot that touches this area, and then as bills are released, that's when I think we're also happy to share our review, so it's not as big of a workload. But the real tricky thing, as experienced folks know, is when concepts get snuck into bills that don't look like they're going to have it. So the big thing to watch for is what chapters are being opened, and then track bills that are playing around in that sandbox.
Great. Mr. Blakey.
Yes, if you need someone else for that committee, I'll be more than happy to help.
Okay. Thank you. All right. Hearing no other volunteers, I think we've got the group that has volunteered, and then Susan to sort of kick us off with what her team has gathered to get them going. If we're good with that, I'll move us on to the item C, which is the department requests. And we've got 2 items under there: judicial fiscal outreach and education work group, and then the 5-year reg review. So, Mr. Handy.
Yes. So the first one is it's becoming more and more apparent that there's some communication and education gaps between what the department does and is doing and judiciary's understanding of both their roles, the department's role when it comes to things like both appointment and selection of counsel and approval and payment fees. So we're hoping that we can work with either members of judiciary on the board, ideally, or other members of the judiciary and or administrative office of the courts to provide some education, outreach, help build a better rapport, let the judiciary know that we can be a resource to them as well, especially if they have questions, concerns, and that hopefully we can get a mutual understanding of how our roles are different, where they overlap. We don't want to intrude on them doing their jobs at all. And I think there's an opportunity to have a more beneficial relationship. So something we want to do in hopefully the near future is really start to begin that outreach and education with the judiciary.
So are you looking for a work group? What is your?
Yes. So
Okay.
anyone who has significant ties to judiciary would be very helpful, I think, in rolling this out. It was something that Justin Maupin expressed briefly at the meeting in Fallon, was having more communication and providing education to the judiciary.
Okay. Anyone interested that has a relationship with the judiciary that could assist?
That leaves me out. Oh, you mean the judiciary anywhere in the state?
Yes, anywhere in the state. They're all important.
Peter, this is Judge Fairman.
I'll throw my name in there.
Thank you, Joni. Go ahead, Judge Fairman.
I'm not sure I completely understand what you believe that the role is going to be and what we hope to achieve. If you could go over that again, just for me, I'd appreciate it.
Sure, yeah. So the idea would be somebody who can help build relationships between the department and members of the judiciary. Somebody who can facilitate meetings, better communication. If needed, act as an intermediary. I don't think it's necessarily that's not a necessary component. But somebody who understands the judicial perspective, help us provide education in a way that they can be receptive to, available for, and help us make those connections in both directions, right? Because I think we could benefit greatly from having more input from members of the judiciary and to be able to educate them on, updates with the laws. The department kind of grows and changes over time, and the role of the judiciary kind of has to adjust, not hopefully too much, to match it.
If I could give a bit of an example without giving an example of homicide for the record, sometimes we receive orders from courts that effectively say DIDS must do this, and that's kind of a tough spot to put us in when we weren't a party, we weren't aware, and the order is often something that we are not legally able to do, such as divert from budgetary requirements. And so we were brainstorming. We don't want to be non-responsive to a member of the judiciary that's sort of sending out that kind of call, but we were trying to think of the best way. Maybe if their peers were coming to them and saying, that's, getting this and this paid for is great, here's the path, versus a blanket court order that says DIDS go do this and we can't.
You envision like on-site meetings with the various jurisdictions and the judges in the various jurisdictions, or the chief judge, and if there's more than one. Usually there's only a couple of them in the rurals anyway. If there's more than one, there are not many judges. But what's your concept on that?
Yeah, I think that's the concept. If not just actual site visits, just communication pathways that are better than just us calling the JEA, because I don't think that's helpful for relationship building in many of the rurals or the judges. Yeah, certainly. So us going on site, having meaningful conversations, being able to discuss with members their concerns about attorneys practicing before them, about issues with our department, about how we can again assist them with any issues that they're seeing in their courtrooms that are part of our purview.
Volunteer.
Thank you, Judge Fairman. So you've got 2.
Fantastic.
Tony, you said you were going to do it, right?
Sure.
Okay.
Thank you. Really, really appreciate the support.
And if anybody else is interested, we can have them reach out to you too.
That's perfect.
Or, Madam Chair, this is Jared Hickman for the educational piece of that work group. Are there, I believe at least at one time, there was a limited jurisdiction judge conference and maybe something similar for the district judges. Is there opportunity to get on those agendas to provide some of the educational piece?
Peter Haney for record, there is, Brenda previously gave a presentation at the Rural Judges Conference, which is separate from the Conference for Limited Jurisdiction Judges. So yes, there are some opportunities there. Those are, as far as I understand, those are generally planned and facilitated by the AOC. So we can certainly work with them to try and develop training. Again, we don't want to interfere with other training that they might think is more important or prioritized, right? But certainly make ourselves available.
We've asked if they would invite us back, and so far they have not yet.
Okay.
It's because you were so good. Almost there.
Thank you. Okay. How about the 5-year regulation review?
Yes, this one is not a work group request. It's actually something that we've considered doing. The regulations, even though they're finally codified this year, the first set's actually 5 years old. Somebody else in the room with us was actually a part of drafting those original ones, and nobody else at the table was. So it's generally a good governance practice to review regulations that are promulgated by an agency or a board every 5 to 10 years. I just wanted to put before the board that now might be a good time to revisit regulations, not necessarily to change them, but just to have somebody or the entire board kind of take a look at them, determine whether circumstances have changed since the original promulgation of the regulations, whether they should be changed and how, and also give the community that we're regulating and supporting an opportunity to weigh in front of the board, give kind of a public comment about how they think regulations should or potentially should not be changed. It's not meant to have a particular outcome, just to give, I guess, a forum for both interested persons, stakeholders, and for the board to just openly discuss opportunities for regulatory changes.
Okay, board members, comments on how that might be rolled out? Jared, you look like you have something to say. I think you were part of the original, maybe?
Yeah, thank you, Madam Chair. Yes. Yes. My question to the department, and this might be a better starting point than turning it over to the board. Are there regulations that in day-to-day practice you think are in need of revision? And if so, what might mock-ups of those revisions look like?
We have to agenda as a separate meeting for that, probably. There aren't that many from my perspective. I think I can speak for us that really need substantive changes. Most of them are working for us relatively well right now. I do know that there are attorneys that we work with that would like to see some changes potentially in the areas of qualification, in the area of potentially appeals of qualifications. There's some that have raised concerns with. I'm blanking on the other one that was recently raised, with some of the contract requirements. Again, as we all know, there's a long history behind a lot of these regulations. Many of them are result of the Davis consent judgment or of best practices or of the conditions at the time necessitating the regulations. So there's none in particular that I can think of that I would recommend to the board to change. Otherwise, I think I have to do that if I come up with a change, under my statutory obligations. But again, this would just be a review and a forum for that input to be heard.
And Peter, how does this tie into the governor's executive order, or does it?
It doesn't at all, actually. I thought about this at the last meeting before the executive order came out. So this is something that's already on our radar to consider, especially as we go into closing reaching the end of the compliance period for the amended Davis consent judgment. And as we look to trying to potentially, anytime there's a statutory change in the legislature, it seems like we might have to have corresponding regulatory changes. So kind of a review in advance of that with kind of an eye to the future. That's what I was thinking.
would it be if the department doesn't have any, or maybe a limited amount of specific requests or ideas in terms of regulatory changes, would it be worthwhile or proper, maybe is the right word, to hold a workshop on regulatory review to invite public feedback and comment on the regulations to get an idea of what might be impacting practitioners?
Peter, Andy, yes, I think that would be appropriate.
Perfect. All right, well then let's have that proposed workshop be fleshed out a little bit more with staff, and we can put that on another agenda if that works. To discuss
yes,
or
Peter, Andy,
to
for the record,
calendar.
yeah, that's good enough direction for me.
Okay. Any other comments from the board before we move on to item number 8?
Nope.
Thank you. All right. This is, I like to give Joni credit here. This is our opportunity as board members to offer announcements, updates, or request topics for future agendas. So this is not a discussion item, but this is our ability to throw our thoughts into the public record. Joni, do you have anything?
Yeah, I do have one thing. I wanted to update the board on something. I know that I had shared quite some time ago, and Peter and I have talked about it extensively, that Esmeralda County, the sheriff of Esmeralda County had signed a contract with the sheriff of Nye County to house Esmeralda County inmates. There is no contract any longer. In fact, it had expired for more than a year. And in discussions with Pool Pact, I'm on their risk management board, and in discussions with Pool Pact risk management, I've discovered that Esmeralda County has instead signed a contract to house prisoners with Mineral County. So now all of their inmates are being housed in Hawthorne, and I thought it created problems with public defenders before, but I would think that this is certainly worse. At least the public defenders who were representing those clients, the majority of them were in Pahrump and Las Vegas, and I'm not aware if they did, but they could meet with their clients right there in the Pahrump jail. But I don't know that there's any way that a public defender could meet with a client in Hawthorne when he or she is located in Vegas or Pahrump. So I just continue to be very concerned about that and wanted to bring it to the board's attention.
Thank you. Other
Wow.
board comments? Yeah, I know.
Yeah,
we can't discuss
they're not.
it, but
They don't want to use. They don't want to use Nye County anymore.
So justice delayed is justice denied, as Joe Neal used to always remind me. So legally, is there any, I mean, we can't take any action. We just, I thank you for bringing it to our attention, Joni. Is it something staff could look into and then report back?
Peter Handy, for the record, yes, we can. This is something that we can actually add to the agenda items number 7 to be a recurring item until the board would like to remove it. My thought is that I'd reach out to practitioners in Nye County who would be representing these clients and see what their experiences are and how they're going about seeing their clients if they're being held in Hawthorne. I'd also like to know, though I don't know if it has the information, what the average detention time is for those clients and how they're getting back to wherever they're coming from.
Yeah, I don't have the answers to any of that, and I'll add an interesting postscript. And I think Lorena's on the phone. She's certainly welcome to chime in on this. But this interesting postscript is that at the last Board of Commissioners meeting in Pahrump, and that was on Tuesday of this week, the sheriff brought a new contract forward with Esmeralda County, and the board approved it, which I thought was very interesting. Nobody asked if Esmeralda County had approved the contract, and I subsequently called a friend of mine who sits on the Esmeralda County Board of Commissioners, and he said that no contract ever came before them, an updated contract with Nye County. So I just think there's a lot of confusion all around, and Pool Pact is adamant that the Esmeralda is not to use any Nye County facilities.
Okay. Thanks, Journey, for flagging that. Sounds like, Peter, you're going to do some diligence, and we'll get that put on the agenda as a standing item until it's resolved. Okay, thank you. Other announcements, updates, requests for information, topics for future agendas from any other board members?
Reconfirm our next meeting date.
Yep, that's our next item. So thanks, Chris. Well, if hearing none on item 8, let's move on to item number 9, which is upcoming meetings. So this is a suggestion to return to quarterly meetings. And so we would like to get some dates for the remainder of this calendar year. Do you have some suggestions?
Do we really want to do that?
Mr.
This is Jared Hickman for the record. I share Jenny's concern.
Yeah, and this is Peter Haney for the record. I've got no objection to the board maintaining whatever cadence to meetings they'd like. This was just a recommendation. We originally had quarterly meetings historically. Those were moved to monthly in anticipation of the shorter amended consent judgment deadlines. Of course, the board is entitled to whatever scheduling cadence they'd like, and we're happy to continue to work with you to meet those cadences. We hadn't set dates in September, in part because we weren't sure if and when the monitor's report was going to come out related to the deadline of the Davis consent judgment. We're happy to work with the board on proposed dates at the board's direction.
Mr. Blakey, you have your hand up.
Madam Chair, I would just like to say monthly meetings, I think, are very important at this moment, and I think the agenda itself will tell us when it's time to go to quarterly meetings.
Yeah, we have a lot of work to do yet.
Chris. Oh, you're on mute. Chris G., you have your hand up?
I'm so sorry. I would say in the future, we should always make sure we meet at least monthly during legislative times, and then down the road, depending on what drives us on the agenda, then can always consider quarterly at that time. And meetings can always get canceled if there's no agenda items to discuss. So
absolutely. All right. With that being said, Mr. Handy, you're hearing from your board that we'd like to continue monthly for at least the interim. And then when our agendas start getting light enough, we can pace those back. So are we looking for a September meeting?
We can look at dates in September, early October. That's about a month from now.
I would suggest October, and personally, I'm going to be gone in September, but I think we have some information that's going to be coming later in September rather than, so maybe October make better sense.
Okay. Do you have a good October date to throw out for us?
So we can do as early as Thursday, the 1st of October, or subsequent every 7 days, the 8th, the 15th, or 22nd.
I'm sorry, for the record, I don't know if there are like memorial services on the 1st of October in Las Vegas that would affect board members for that one. Just throwing that out there if people are looking at calendars.
Why don't we look at the 8th then?
Okay. Works for me.
Yes, 8th sounds good.
Any objections to having a meeting on the 8th by any board members? Anyone can't make it?
No, that sounds good.
Okay. Let's proceed with that meeting date. And then maybe if we could, let's get a November meeting on the books. And then we'll see how the holiday time looks.
Okay, we'll get some polls out. We'll get some polls out for November and December.
Great. Okay. Thank you, board, for your input. I appreciate it. And given that we're already at 2 hours and 8 minutes, I think that our agendas are leaning towards needing to be monthly, at least for the near term. Okay. Any other comments on item number 9, upcoming meetings? Then let's move on to final public comment. I'll remind everyone. Oh, Franny, it looks like you have your hand raised. Please go ahead with your public comment.
Hi, this is Franny Forsman. Speaking as Franny Forsman and not as counsel for Davis, I'm not sure I understood Deputy Director Sayers' brief comment with regard to indigency qualification. And I just want to warn that occasionally it has happened, and it happened in Clark County, that the defense attorney gets drawn into not just collecting financial information, but also making recommendations or having some involvement in qualification of the client for services. And it's a disaster when it happens. And I just urge you not to get caught in that trap because it creates a conflict between the client and the attorney.
Thank you, Commissar. For the record, just to mention the reason I mentioned it was to avoid that because people are reporting that they're getting sucked into it, and we need to push them to the resources that exist and not have them act as social workers. So that, thank you. It's very well taken that that's not fair or appropriate.
Yeah, okay, great. Thank you.
Thank you, Franny, for your public comment. Public comment. Any other members would like to chime in on public comment? Final public comment for the meeting.
I would like to. This is Derek Lopez. I'm having trouble raising my hand, so.
You're all good. Thanks for jumping on. Please take the floor.
I just wanted to kind of end with a couple positives. One, I'm very excited to hear that Mark Picker is coming on to assist the State Public Defender's Office, even on a temporary basis. I think he brings valuable knowledge and experience, and having worked with him a bit, I'm very hopeful. I think that's a great thing. The other thing I wanted to mention was that a number of the attorneys that are filling in to assist because the public defender's office is short-staffed and have contracts or doing hourly work are doing a very good job. And just a shout out, Massey Mayo, who consistently does an excellent job for her clients from what I'm observing, just concluded a trial that started last week and finished yesterday with an acquittal on all 6 counts. And what I'm hearing through the courthouse, I'm in Winnemucca today, is that she did an excellent job. So a lot of praise for that work. But I wanted the board to be aware of it. So while the public defender's office has been struggling to maintain staff, there is quality representation going on in Humboldt. And that's really all I needed to say.
Thank you so much for your comments. We do like to end on a positive note, not to challenge anyone, not to put their comments on the record, but if they're
I have one, Madam Chair. It's Patrick Mansfield.
Go ahead, Patrick.
Thank you. I appreciate that, Derek. I wasn't going to touch on that, but obviously we're pretty impressed by that as well. Not only was it 6 felonies, 2 of them were attempted murder, so it was higher up on the gamut, right? So,
awesome.
But aside from that, what I wanted to make on public comment was about the remote situation. As everyone knows, my office is relatively high in the remote section or quarter of it. I think it's a very good, useful tool. I understand how it started, but I think that people can really benefit from it. People being defendants, the courts, everyone else, if it's used right. I've said it before, that it can be abused, and I understand that, but it's very useful. I mean, look at what we're doing here. The whole helm is via remote. So if it's used right, it's a very useful tool. So with that, I would like to throw my hat in the ring to be part of the work group. So
thank you.
Thank you.
Thank you for your comments. All right. We will reflect that request for the remote appearance work group from our public commenter. Any other public comment from any members of the public? All right. I'm not seeing any. So with that, I will call our meeting of the 20th board meeting to close, and we will see you all next month. Or no, we'll see you all in October.
Good job. Thank you.
Thank you, everyone. Be safe.